Thank you for your participation to an event on celebrating India-Japan partnership, focus, mergers and acquisitions, and joint ventures between Indian and Japanese companies, a legal perspective today. 皆様、本日は日印パートナーシップ記念、インド企業と日本企業の M&A とジョイントベンチャー法的視点からと題したセミナーにご参加いただきまして誠にありがとうございます。First, may I invite His Excellency Mr. Shibi George, Ambassador of India to Japan, to give inaugural remarks. はじめに駐日インド大使シビ・ジョージ閣下より開会挨拶をいただきます。
Good afternoon, everybody. Representatives from Kuntra and Bansal Associates, Mr. Shivendra Kuntra, partner, Mr. Subodh Prasad Dio, partner, Mr. Alok Vasant, counsel, distinguished guests, ladies and gentlemen. It's an honor to address this distinguished gathering at this important seminar on mergers and acquisitions. As we navigate an era of global economic transformation, the time is ripe for Japanese enterprises to explore the vast opportunities that India presents in the M&A space. Today, as we discuss this important subject, we are not just talking about business collaborations. We are envisioning a future of deeper economic integration and strategic collaboration between our two countries. Friends, India today is one of the fastest growing major economies in the world, projected to be a 5 trillion economy by 2030. With a sustained GDP growth of over around 6-7%, a large consumer base of over 1.4 billion people, and a dynamic startup ecosystem, India offers unparalleled opportunities for investment and expansion. India and Japan have always enjoyed long-standing dynamic partnership relationship based on values of democracy, peace, and mutual respect. Our strong G2G relationship has resulted in a vibrant B2B operation, strong people-to-people connect, and has emerged into what we call a special strategic and global partnership. Japan has been one of India's most trusted economic partners, with companies such as Suzuki, Hitachi, Daikin, you name it, they're all there. 1,500 Japanese companies and 5,000 branches all across the beautiful landscape of India. Today morning, I had the opportunity to address another seminar which was on India and Japan together in Africa. Japan has been a partner of India for the last several decades, and 1,500 companies means 1,500 success stories. And it is an opportunity for Japan to expand that numbers. 2 surveys done both by JETRO and JBIC shows that maximum number of Japanese companies want to expand in India. A very good sign. So my target is to convert or to increase this 1,500 to 15,000. What we need is a quantum leap in our relationship. We have everything right. We have excellent civilizational connect. We have excellent political relationship, excellent business relationship. We have very good people-to-people connect. We have defense and security cooperation. What we need is to address the issue related to the numbers. We need to have more Japanese companies in India. Come invest in India, be part of India's growth story. Come and make money in India. Making money is not a crime. Make money in India. Let us grow together. India is a land of 1 billion opportunities. Don't miss it. If you look at if you travel in India, you will find that there are more cranes operating in India than anywhere else in the world. More highways being built in India. More airports and railway network is being built. In each of these, we would like Japan to be a partner. Japan has been a partner, but we want Japan to be a closer partner, to be able to avail the opportunities that India offers. In the last 2 years of my stay in Japan, I had the great honor of traveling all across this beautiful country. I visited all the 47 prefectures. There is a momentum for India, a momentum for India-Japan relationship. You go to any corner of Japan, you will see that there is an interest for India. India's transformation is generating huge interest in Japan. We need to convert that into business opportunities. Last year, we had 9 governors of Japan visiting India, leading business delegation. This month alone, I will have 4 major business delegations going from Japan to India. 4 major business delegations. Kedantran, Japan Chamber of Commerce, Japan India Chamber of Commerce, Keisai Yokai, and a semiconductor delegation led by the JETRO. So 4 major delegations are going all across the country. Things are happening. My target is also the SMEs, small and medium scale companies. Japan is a country of SMEs. My target this year is to reach out to 100,000 SMEs in Japan. We can do it. We need to connect with the chambers. We need to connect with the small and medium scale company clusters in many parts of the country. That's what we are doing. I really appreciate the efforts of our law firms, our associates like Kuntra and Bansal Associate, who has taken the initiative in organizing this event. In my meeting with them, I was telling them that, make it a pattern to come to Japan more frequently. 1 visit is not enough. It should be 3 visits a year. And each time let's meet people, follow up with people. Go, and not only in Tokyo. Tokyo alone is not Japan. Japan is much bigger than Tokyo. Like Delhi alone is not India. Washington DC alone is not US. We need to reach out to the all corners. In Japan, there are 47 prefectures. At least 30 of them have more than 50 billion GDP. And each one has a manufacturing base. We need to identify that. We need to work with them. We need to inspire them to look at India. India has transformed. So once again, I thank the Kuntra and Bansal Associates for taking this initiative in organizing this event. We are fully with you in your efforts to connect with the Japanese companies. And I once again thank each one of you for joining us today. Thank you and good afternoon.
Thank you, sir, for the remarks. Next, I would like to invite Mr. Shivendra Kundra, partner, Kundra and Bansal Associate, to make presentation on M&A and joint venture for Japanese company investing in India, the role and the way forward. 続きまして、クンドラ&バンサルアソシエイトパートナー、シベンドラ・クンドラ様より、インドに投資する日本企業の M&A とジョイントベンチャー、法律と今後の進め方についてご講演いただきます。
Konnichiwa. Good afternoon. The Ambassador, His Excellency, Mr. George, has already made some very valuable comments about Indo-Japanese economic relations. And we are going to make 3 short presentations introducing some of the concepts and examples related to merger and acquisitions and how the law has unfolded in recent times. My first presentation will be on mergers and acquisitions as they take place in terms of the various laws. There will be a follow-up presentation by my colleague, Alok Vasant, on how to integrate after the M&A has actually taken place. And finally, the third presentation will be by my colleague Subodh Prasad, who will talk about how competition law impacts mergers and acquisitions in India. So there is obviously a myriad of laws, many laws that impact mergers and acquisitions in India. But these are some of the key laws. And obviously, at the top of the chain is the Companies Act and the Companies Compromises and Arrangement Rules. And these are some of the other laws. I will talk about them as we go along. But essentially, when you do an M&A transaction in India, these are the key laws that you take into account. Next slide, please. These are some of the additional laws. The reason we've put it into the presentation is because these specifically govern cross-border M&As. That is the Foreign Exchange Management Act, which is essentially an act that governs inflow and outflow of foreign exchange into the country. The Foreign Exchange Management cross-border regulations, which actually provide for the inbound and outbound merger processes. And the Reserve Bank of India, which is a federal bank, approves the merger process. Next slide, please. In India, the terms mergers and joint ventures are not explicitly defined under the Companies Act or under the Income Tax Act for that matter. Merger is the process of combining two or more distinct entities in such a manner that it amounts to the accumulation of the assets and liabilities of the said entities into one business entity. This, I don't think, is different from what it would be in Japan or indeed in any other part of the world. The Income Tax Act defines amalgamation as the merger of one or more companies into another company, or the merger of two or more companies to form one company, in such a manner that the assets and liabilities of the amalgamating companies vest in the amalgamated company. The basic ingredients of amalgamation are as follows. All of the properties and liabilities of the amalgamating company or companies immediately before the amalgamation become the properties and liabilities of the amalgamated company by virtue of the amalgamation. Shareholders holding not less than 3/4 in value of the shares in the amalgamating company or companies become shareholders of the amalgamated company by virtue of the amalgamation. So the Companies Act has special provisions dealing with mergers and amalgamations. There is an entire chapter which is dedicated to what is called the scheme of compromise and arrangements. These deal with the process of merger and acquisition and the involvement of creditors, and it requires a court-sanctioned process. Now, when I say court-sanctioned process, earlier the responsibility vested in the high courts. It has now moved to a tribunal which specifically looks after company law matters, including mergers and acquisitions. There are provisions within the Companies Act now, and this has been more recent, whereby cross-border mergers can be carried on between Indian and foreign companies, again with certain conditions and requirements of a fair valuation of the assets in the merger process and approval from the Indian authorities. And I talked about that, which is the Reserve Bank of India. And if it is a merger process involving listed companies, then the Securities Exchange Board of India. The Act specifically sets out, and I'm talking about this because valuation is very important, particularly in the context of the Foreign Exchange Management Act. The Act sets out rules of valuation of shares, which is necessary for determining the share exchange ratio between the companies involved in the merger or acquisition. And the valuation must be done by independent valuer appointed by the company's board of directors. The Act also provides protection for minority shareholders. The Companies Act requires that the shares of minority shareholders be treated on par with the shares of the majority shareholders, and minority shareholders have the right to object to the merger or acquisition and can ask for fair value of their shares to be determined by an independent valuer. Next slide, please. The Securities and Exchange Boards of India, their rules and provisions come into play only if it's a merger and acquisition involving listed entities, that is, entities that are listed on the stock exchanges. One of the ways to achieve, SEBI achieves the primary role of regulating the M&A process is by actually laying down certain processes for M&A in India in the securities, within keeping in mind the framework of the securities market. SEBI regulations require companies to disclose information about M&A transactions to the stock exchanges and to their shareholders. This is to ensure that all relevant information is made available to the investors so that they can make informed decisions about their investments. The information that must be disclosed includes the terms and conditions of the proposed merger or acquisition, the valuation of the companies involved, and any potential risks or benefits associated with the transaction. SEBI also specifies the procedures for obtaining approval from the stock exchanges for mergers and acquisitions. The companies involved in the M&A transaction must submit a draft scheme of the merger or acquisition to the stock exchanges for approval. The scheme must include details about the companies involved, the share exchange ratio, and the benefits and risks of the transaction. The stock exchanges will then review the scheme and provide the approval if they find that the scheme is in compliance with their regulations and objectives. Next slide, please. The SEBI Substantial Acquisition of Shares and Takeover Regulations, also known as simply the Takeover Code, govern the acquisition of shares and ensure that shareholders are treated fairly during M&A transactions involving listed companies. Key provisions of these regulations include an open offer. When an acquirer gains substantial control over a company, which is 25% or more, they must make an open offer to the remaining shareholders to purchase the shares at a specified price. And substantial control can either be in terms of the shares or management control. This process protects minority shareholders from unfair treatment. Disclosure of shareholding. Additionally, acquirers must disclose their shareholding patterns and any changes to the SEBI, that is the Exchange Commission, the Securities Exchange Board, and the stock exchanges, fostering transparency in the market. Next slide, please. Cross-border mergers are of two types, inbound and outbound. Inbound means a cross-border merger where the resultant company is an Indian company. An outbound merger means a cross-border merger where the resultant company is a foreign company. As per the regulations, merger transactions in compliance with these regulations shall be deemed to have been approved by the Reserve Bank of India, that is the Federal Bank, and hence no separate approval should be required. In other cases, merger transactions would require prior RBI approval. Inclusion of such deeming approval provision under the regulations has relaxed the mandatory requirement as set out in the Companies Act to seek prior approval of the Reserve Bank of India for cross-border mergers. It is also required that a certificate from the managing director or the whole-time director or company secretary concerned ensuring compliance with the FEMA regulations be filed with the application made to the tribunal in relation to the merger. The FEMA merger regulations also make it mandatory for the Indian company and the foreign company involved in the cross-border merger to furnish reports as may be prescribed by the Reserve Bank of India in consultation with the government. Next slide. We now come to joint ventures. As you probably know, many of the Japanese companies in India entered through the joint venture route, which is not unusual. And I dare say some of them did face issues. And how do we address that? It's been addressed. One, I think the most significant way of doing it is by ensuring that the documentation you do, which is in terms of a shareholders agreement, has certain key elements. And also the structuring, the share structuring is significant. The courts in India have also played a significant role more recently. They have encouraged fair play, ensuring that there is no detriment to the Japanese companies in terms of interpretation of the contracts. So what is the percentage that you should consider in a joint venture? So simple majority is 51%, right? What are the key rights that come with simple majority? You get the opportunity to control the composition of the board of directors, the appointment of the auditor, the adoption of annual financial statements, and declaration of the annual dividend. If you are able to wrest more than 3/4 control of the company, then you get this additional advantage, which is you have the opportunity to amend the bylaws as and when you desire, alteration of share capital, including preferential allotment or buyback, removal of auditors, mergers and amalgamations, and approval of significant investments, loans, and guarantees. Next slide, please. What are the key considerations in a joint venture agreement? What are the things that we should keep and bear in mind while drafting such agreements? Share capital and subscription. This defines the total authorized shares, classes of shares, and their par values, establishing the ownership framework and corresponding voting rights. Increase in capital and issue of new shares. Procedures should be outlined for raising additional capital as the company may need, and these often involve issuing new shares. Shareholders' agreements may include preemptive rights, allowing existing shareholders to maintain their ownership percentage by subscribing to new shares before they are offered to external parties. Transfer of shares, that is call and put options. These options provide mechanisms for shareholders to buy, which is call, or sell, which is put shares under predefined conditions, facilitating planned exits or ownership changes. Governance. Shareholders' agreements typically outline governance structures, including decision-making processes, board compositions, and the extent of shareholders' influence over strategic decisions. So you can have, for example, a case of an affirmative vote, even if you are not in majority. Preemptive rights or right of first offer and the right of first refusal. These rights protect existing shareholders from dilution and unwanted third-party influence by granting them the opportunity to purchase shares before they are offered to external buyers. Anti-dilution protection. Dispute resolution and exit strategies. Provisions detailing mechanisms for resolving conflicts and outlining exit strategies such as buyouts or public offerings to ensure smooth transitions and continuity. Management, control, and administration. I've already talked about affirmative rights and reserved matters. Quorum and voting at meetings, establishing the minimum number of shareholders or directors required to be present for decisions to be valid, ensuring that significant decisions reflect a consensus among key shareholders. Intellectual property, ownership and development. In joint ventures or collaborations, it's crucial to define the ownership of existing IP and new IP developed. Agreements should specify how IP rights are shared or licensed or transferred among parties. Protection mechanism. By this, we mean implementing measures to safeguard IP assets, including confidentiality agreements, patent filings, and restrictions on the use or dissemination of proprietary information. Next slide, please. Of course, before you do any process of restructuring, either as a merger or an acquisition, you undertake a due diligence. What are some of the points to consider in a due diligence process? But these are some of them. From corporate and shareholders records to management records, personnel records, banking and financial records, material contracts, real estate, intellectual property. And I'm not going to repeat, it's already there on the slide. You can see some of these, but it's obviously before any merger or acquisition is approached, a due diligence process is critical. And it's very, very important. We've noticed that many a time parties are not very forthcoming with information regarding some of the contracts that they have entered into with third parties. I think that it becomes key to be to ensure that such information is actively sought out. Next slide, please. We'll now talk briefly about the procedural aspects of M&As and joint ventures. Pre-transaction planning. Before the transaction, companies should conduct a thorough analysis of their own strengths and weaknesses, as well as those of their potential partners. Very important in the Indian context, as it's important because as a joint venture partner from Japan, you should know the strengths and weaknesses of your partner. Probably engage an outside consultant to do this for you as well. They should also identify areas of overlap and determine the strategic fit of the transaction. Valuation. Both companies should determine the fair value of their assets and liabilities to establish a fair exchange ratio or price. This process typically involves hiring a third-party appraiser to provide an objective valuation. Due diligence, which we've already talked about. Then we go on to negotiations. Once the due diligence process is complete, both companies should enter into negotiations to establish the terms of the transaction. Again, that will include negotiation regarding terms to be included, provisions to be included in the shareholders' agreements, or other such documentation. And finally, the regulatory approvals. Depending on the nature of the transaction and the industries involved, companies may need to obtain regulatory approvals from the board of directors, shareholders, and various other stakeholders, including regulatory agencies and government agencies. Integration, which will be talked of by Alok later, and the post-transaction evaluation. Finally, both companies should evaluate the success of the transaction and identify any areas for improvement for further integration. This evaluation process should continue over time to ensure the ongoing success of the combined entity. Next, please. So these are some of the exit routes available. I think it's equally important to understand when you enter into a partnership with an Indian company, or if you have undertaken a merger process, you should also be aware of what are the various exit routes that are available. These are some of the common ones, which is including the IPO, the secondary sales to other investors, strategic sales to corporates, and buybacks by original owners. Tax considerations, that these have to be kept into mind, and Alok, you may be talking about this. Capital gains, which is tax applications under the Income Tax Act and under the double taxation avoidance agreements. Next slide, please. So what are the amendments, recent amendments in the cross-border merger framework? Under the erstwhile Act, which was the Companies Act of 1956, a merger or amalgamation of an Indian company for the foreign company was not permitted. However, the amendment to the Companies Act removed this restriction and made the relevant chapter, which is chapter 15, applicable to all cross-border mergers. Accordingly, there was a separate provision that was created for dealing with cross-border mergers. To streamline the procedure and pave the way for ease of doing business, the amendment to Rule 25A of the Company Merger Rules has taken place. It will now include a sub-rule stating that where the transferor foreign company incorporated outside India as a holding company and the transferee Indian company is a wholly owned subsidiary company incorporated in India, when they enter into merger or amalgamation, both the foreign company and the Indian transferee company should secure prior approval from the Reserve Bank of India before proceeding with the merger or amalgamation. The transferee Indian company is mandated to comply with the provisions of the Companies Act, which provides for a fast-track merger route for specific mergers, such as those between holding and subsidiary companies. Hence, they can bypass the National Company Law Tribunal approval route. The application must be made by the transferee Indian company to the central government, which will approve the application, and a declaration has to be filed, which must accompany the application, which will include specific undertakings, such as compliance with the law and the assurance that the scheme is not prejudicial to the creditors, shareholders, or the public at large. Next slide, please. So what are the contractual obligations? The Indian contract law blends common law and civil principles, although the general belief is that India is a common law country, which it is, but there is a blending of the common law with civil law. Importantly, you can choose in your agreement as to what the governing law will be. And I think this is particularly significant if you look at my point number 4, which is damages, because in India, damages are really largely compensatory in nature. So if you, for example, choose a jurisdiction, let's say Japan, I'm not sure as to what the extent of damages may be awarded in law here, but if you choose, let us say, the law of Japan, and the law of Japan allows for, let's say, penal damages, then the agreement would apply. And if there is an arbitration clause, then the arbitrators will be bound by what the parties have chosen as the governing law. So I think it is important that the two, I think from the perspective of the shareholders' agreement, I think the most important points are, of course, or rather the 4 most important points are: 1, the structure, which is your equity percentage; 2, the governing law; and 3rd, the arbitration. I think these 3 are very, very significant points to be considered. And the 4th which is regarding management, as to how you govern the company. So these 4 points are exceedingly important while drafting the shareholders' agreement. Next slide, please. I'll briefly talk about the labor laws because for any manufacturing entity, labor laws become significant. India has a very vast labor market. Um, uh, a lot of them are not in the category of what you would define as labor force, which is aware of its rights and duties. And therefore, it becomes important to educate your personnel about labor laws, as to what their rights are and what their duties are. I think that is very, very significant. What has now happened recently is that there were several labor laws, and states had the power to make amendments to the labor laws. They have now been consolidated merged into four key codes, which is the Industrial Relations Code, the Code on Wages, the Code on Social Security, and the code which deals with safety, health, and working. So what are the objectives? The objectives are to balance workers' rights and economic growth, reduce compliance burdens through consolidation, formalize fixed-term employment, ease closures and retrenchment processes. The right to strike is now subject to conditions, and trade union reorganization and collective bargaining, that has been circumscribed. Next slide, please. Intellectual property rights, I think for a lot of foreign companies, naturally, the protection of IPs has been a matter of concern. But I must say that the Indian courts have been very, very forthcoming and very proactive in terms of enforcement of intellectual property. So if you look at the protection that is offered to intellectual property in terms of codification, in terms of the law, then we have protection, codified protection for trademarks, patents, designs, copyrights, and geographical indications. India is a signatory to the major IPR treaties and conventions. There is, and I was talking about the role of the Indian courts in enforcing intellectual property rights. Ex parte injunctions are pretty much the norm in case of violation. Search and seizure actions against infringement, again, very much the norm. And in India, civil and criminal remedies are available for IPR protection. So this is an extra layer of protection, because you have a criminal remedy also, and common law remedies such as passing off, etc., are also available. Next slide, please. This is a general slide. His Excellency, our ambassador, has already spoken about it. But what we are now seeing is that initially it's not that it stopped, but there is a move by Japanese companies to own the companies wholly in India now. As more and more Japanese companies have expanded into India, there has been a tendency to acquire full control also, acquisitions, particularly with Japanese companies which already have a presence in India. Increase in mergers and acquisitions. There has been a huge surge in the merger and acquisition space in India. In the last year, in the first 3 quarters, there was a 66% increase. Although the world standard, I think it was about 10%, but we're seeing that there is a massive surge, and there's a huge opportunity for Japanese companies to invest in India. Many of the state governments, like your prefectures, are offering special incentives to companies. They are competing with each other for garnering investments. So I think there is an immense opportunity that is available India is a growing market. India's the workforce in India that is available to companies, to Japanese companies, is of such nature where you can balance between the very skilled and the semi-skilled. So there's been specifically, we've seen an increase in some of these sectors, which is chemicals, retail and consumer goods, healthcare and information technology. And there has also been an increase in the foreign direct investment policy change. There's been some changes. The cap has been increased for foreign investment from 26 to 49%, and that has seen some Japanese companies increasing their stake. Next slide, please. So these are some of the examples of India-Japan collaborations. Sumitomo Corporation, we have a speaker later from Sumitomo Chemicals. Maruti Suzuki, which many of you will be familiar with. It was one of the biggest joint ventures when it first came up. It completely changed the automobile space in India. It was really the front runner. Mumbai-Ahmedabad high-speed rail, that is the bullet train project. Japan-India Industrial Competitive Partnership, which is for enhancing industrial cooperation. Japan Industrial Townships, Delhi-Mumbai Corridor, Asia Energy Transition Initiative, and Mitsubishi Hitachi Power Systems India is in power sector collaboration. Next slide, please. So this is the road ahead. I'll just leave it to you to sort of look at the slide. I don't have to read it out, but these are the opportunities. There are, as I said, and as has already been said by our ambassador, that there are immense opportunities that exist. I think from what we know, that JICA has identified India as the prime location for Japanese investors. So the doors are open, and we hope that we will see you, more of you there. Thank you.
Thank you, sir, for your presentation. Next, I'd like to request Mr. Alok Vasant, Counsel, Kundra and Bansal Associate, to make presentation on M&A due diligence, post-M&A integration, including compliance and financial reporting. 続きまして、クンドラ&バンサルアソシエイト顧問弁護士アローク・バサント様より M&A デューデリジェンス、コンプライアンスと財務報告も含む M&A 後の統合と題した講演をいただきます。どうぞよろしくお願いします。
Good afternoon, everyone. Konnichiwa. It gives me immense pleasure to interact with you in this auditorium. I'm really pleased to see so many people coming up here and taking interest in the India story. And I first of all want to thank the Indian Embassy, His Excellency Mr. George, for giving us this opportunity to come and present before you. My name is Alok Vasant. I am a chartered accountant as well as a lawyer. Over the last 26 years, I've been advising a lot of multinationals who have come and set up shop or set up bases in India, both as a chartered accountant as well as a law professional. I've helped them set up companies, entities into India, and to navigate the legal aspects, the tax issues in India, and be successful in their ventures in India. That's what I've been doing for the last 26 years. And this is my intention, that I come and tell you about the Indian opportunity, and wherever you think, I'm there to help you, assist you in reaching out, and most importantly, to see what are the nuances when one wants to come to India, one wants to set up a venture in India. What does it take to do manufacturing? What does it take to set up a call center or a business process outsourcing entity or an R&D center? I mean, that's what I'm looking forward to from this session. So feel free if you think you want to ask something, I will be happy to pause my presentation and answer that. So that's what I want to do over the next 20 odd minutes. So my topic is uh, Shivan already talked about mergers and acquisitions, the legal parameters and the legal issues. Uh, what is very significant? I mean, you go and identify an Indian target entity that you want to combine with or you want to partner with. But a lot of times you later realize that probably that partnership is not working well, right? And that is where we need to be very, very wary that we choose our partners right. We understand the landscape in that country, in India. We understand the laws and we know how to navigate that, right? So my topic is M&A due diligence, and due diligence happens to be the backbone of any mergers and acquisition transaction that we undertake. Uh, I mean, this helps us to take informed decisions, prudent decisions. Uh, so I think the importance cannot be diminished at all. I mean, if you're wanting to partner with someone, due diligence is the first and the foremost step. It forewarns you, it forearms you, both forewarns and forearms you for undertaking any joint venture or a merger or an acquisition for that matter in India. And once the merger happens, what is more important is also to make sure that the integration happens right? So because there are two different cultures which are coming together, there is already an existing culture within the organization in the country. Japanese investors or Japanese management will have a different way of looking things. So what is important is to ensure that the cultures marry, the cultures get along together so that there are no conflicts and the venture becomes successful. It's like a marriage happening where two people join hands together, right? And then there are certain reporting requirements which happen when you do a merger. So just to set the context, I mean, before we go into all these three aspects, I think what is important is to look at what is the opportunity that India has today and what are the areas that investors from Japan can look at when looking for partners in India, right? So next slide, please. Yeah. So India is, I mean, obviously, His Excellency Mr. George did mention about it. It's a land of opportunities, fifth largest economy today, just behind Japan today. So India and Japan almost there, poised to be the third largest by 2030. Fastest growing economy, 6 to 7%, large economy, 6 to 7% GDP growth rate. And we have, I mean, over the last 10 years, the macroeconomic and the fundamentals have improved significantly. India was at, I mean, some 15 years back, it was categorized as a fragile five, and now it's one of the most promising economies. And I mean, I think a lot of countries are now looking India as a manufacturing base after China. So that's the potential that India holds today. Uh, Obviously, largest pool of uh, skilled professionals and engineers in India. And it also is true for when it comes to AI and cloud computing. Uh, I mean, I think India has probably more number of engineers than a lot of countries have a population, right? So that's the strength when it comes to the Indian talent pool. There's a huge focus on digital India. India has transformed uh, its day-to-day operations significantly. I mean, everyone transacts digitally in India. You have UPI, which is the Unified Payment Interface. You can see small street vendors having a QR code with them, and you can pay money as less than 10 rupees, which is not more than 20 yen, and they'll be happily accepting that money digitally, right? So that's the power of digital India today. I mean, the transactions which happen on a daily basis are humongous. Uh, World's top IT companies are in India. You name them, and they are there. Either they have an R&D center or they have a back office center in India supporting their uh, software and IT operations. So this is what the India story is, and of late, manufacturing is something which is catching up, and that is where I think the opportunity lies. And Japan, I think, was one of the first movers when it comes to automobile manufacturing in India. Maruti is an example. We have Toyota, we have Honda in India, we have Isuzu in India. So uh, from a manufacturing standpoint, Japan has already experienced the strength and power of India. Uh, and when it comes to market, uh, 1.4 billion people, look at the size of the market. I mean, and of that, a lot of them are in the middle age group. You talk about demographics, 65% of them are of less than 35 years age. So you can see what is the promise that's there for consumption, right? So they're all there to buy goods, all there to buy luxury goods. Also, with the GDP growing, the per capita income growing, there's a huge market, right? I mean, you take just $10 from them and look at the size of the market that you're talking about, right? So that's the opportunity. And I think also for Japanese companies, it's also a gateway to Africa. That's what I think. And this is something which is His Excellency Mr. George was also mentioning, that if Japanese investors or companies are looking to also uh, tap the African market, India can be a good place to manufacture goods and then export to Africa. So that's the opportunity we're talking about. There's been huge growth in retail, e-commerce, education, healthcare. So that's the opportunity that Japanese investors could look at, that they could identify right partners in these sectors and then set up a venture in India. And as Shivan mentioned, I mean, the other option is to set up a greenfield venture, but then yes, greenfield has its own challenges. So if you can identify a brownfield venture, you get a kickstart there, right? So next slide, please. Uh, So M&A has been growing in India, and Shivan also talked about it. And I think it's the crucial role for an M&A is that it helps in corporate growth, it helps in market expansion, and it also creates value. So value creation is significant with through an M&A. Suddenly, two people join hands together, and they both bring their own set of strengths to come up with a better corporate entity, which can take on the challenges which the market throws on them, right? So that is where the M&A has its advantage. Yes, there are downsides to it, in the sense that you may not completely agree with the partner. There could be differences with the partner, and there could be those things which can crop up, and that is where a due diligence comes in, and post integration issues one will have to address, so that the M&A is actually successful. The key sectors are manufacturing, industrial automation, renewable energy, sustainability, infrastructure, technology, digital economy. Uh, and the recent trends, when we see at the recent trends, we've seen inbound deals from Japan, and SoftBank has been a huge investor into India. That's the growth story, especially in the startups, especially in the startup ecosystem. They've significantly invested in the tech side, right? And they have benefited out of, because a lot of these startups have gone ahead and listed on the Indian Stock Exchange, and that's where SoftBank has exited and made significant returns on their investments. And that's a new thing which is coming up in India when it comes to tapping the capital markets in India. A lot of foreign companies are tapping the Indian capital markets, and the latest example was Hyundai, who went and listed in the Indian Stock Exchange. Uh, I mean, Maruti has already listed. I mean, it's an old listed company in India, Maruti Suzuki, but Hyundai is the latest example, and there is another Korean company which is scheduled to list in the next couple of months in India. So that's also an opportunity where people are looking to raise capital in India, or looking uh, to take that next step in India. That's where uh, you could look at India also. I mean, we used to listen, we used to hear stories like people have gone ahead and listed in Singapore or in London Stock Exchange, but now you're seeing that there is a trend to list on Indian stock exchanges, because there is a huge amount of cash lying with the people, with increasing GDP and increasing purchasing power in their hands. Uh, So there is consolidation in the banking and telecom sectors, and there is rising private equity and venture capital participation. So India is the third largest startup ecosystem, and there's a lot of work which is happening on the tech side. Uh, I mean, I mean, I can say that if you go to cities like Gurgaon or Bangalore or Hyderabad, you'll see a startup in every third home, right? So that's the kind of power that you have in a startup. Uh, Next slide, please. So some of the opportunities that investors from Japan will have is uh, in the manufacturing and industrial automation. India has a very promising production-linked incentive scheme, wherein if you come and produce in India, there are uh, incentives which are given by the government, uh, which has a total outlay of $26 billion. So that's the support which the government is giving when people are coming here to manufacture. You have a growing domestic demand. India is the fourth largest automobile market globally, and look at the potential for consumption of automobiles. I mean, today the I mean, if you look at number of people owning an automobile, is far less than any other country, and so that's where the potential is. That you come up with your automobiles, you come up with EVs, come up with newer technologies, and the Indian market is there to grab that. uh, and this is where the Japanese expertise can really benefit from. Japan leads in precision engineering, robotics, and lean manufacturing. Companies like Toyota, Suzuki, and Hitachi have already established large-scale manufacturing operations. They have strong R&D capabilities in India. So that's where I think the opportunity lies. Uh, when it comes to investors, lower manufacturing costs compared to Japan, cost advantage of at least 30 to 40%. That's what I can vouch for. You have incentives under the PLI and SEZ schemes. And as I mentioned, that India is definitely an alternative to China for supply chain diversification. Next slide, please. You also have an opportunity, similar opportunity in renewable energy and sustainability. India targets 500 gigawatts of renewable energy capacity by 2030. And there is a strong push from the government, including the state governments. on solar, wind, and hydrogen energy. And Japan is a global leader in solar technology, hydrogen fuel cells, and battery storage. And companies like SoftBank and JERA and Toshiba have invested in the green energy space. So that's another area that uh, companies can look at to partner with the right people in India. Uh, so we can go to the next slide. Infrastructure and transportation, that's another area that companies can look at to come to India. 1.4 trillion investment planned under the National Infrastructure Pipeline. One has to really visit to India to see the infrastructure development which has happened in the last 10 odd years in India. I mean, His Excellency was mentioning about the cranes in India you see today, right? I mean, there's so much of road network, so much of railway network which is happening in India. Metros are getting built in different cities. Uh, Railways getting modernized. You have new coaches, you have new trains. So huge push on infrastructure. And I think Japan is obviously pioneering in that by getting India its first bullet train. So for which work is already on, and we should see that in probably a year or so. So that's a big opportunity for Japanese investors to uh, take to participate in this infrastructure growth which is happening in India. Uh, so if you can go to the next slide. Yeah. And I already talked about technology and digital economy in India. And this is where uh, the Japanese leadership in its AI or IoT and uh, robotics can help India, and we can partner together and take it to the next level. Companies like NEC, Fujitsu, Sony have already expanded operations in India. There's a huge semiconductor manufacturing opportunity which is waiting in India, and a lot of companies have announced semiconductor plants in India. And this is all incentivized by the government through this PLI, through their PLI scheme. So we will be happy to talk about all that in more detail as you have any specific questions around them. So this is just a bird's eye view of what lies in India when it comes to uh, the sectors where we can partner, or we can look for welcoming Japanese investors into India. Next slide, please. So, having talked about it, now come to the real topic which I'm here for. I've already mentioned due diligence is a very significant step before you decide to partner with a Indian uh, Indian player, and typically due diligence will involve these 5 elements. Financial due diligence, uh, which looks at the key performance metrics, the valuation, what are the hidden liabilities, what are contingent liabilities, what is the tax litigation, what kind of working capital does one require in order to sustain, because that's a significant thing, and I've seen in transactions where people have ignored working capital requirements, and then they have kind of suffered because of that. Then you have operational due diligence, where you look at HR and labor policies. You see how people integrate, what are the compensation policies, uh, what benefits are the existing people already getting, how can the new investor which comes in make sure that they get the right compensation, so that they don't leave the merged entity, because that's something which a lot of times we encounter, that people leave once a merger happens, right? So we need to engage with the key people in that entity. Tax due diligence is very important, because it helps you to see if there are any litigations, any pending tax disputes, because that can result in a significant cost later on. Shivan already talked about legal aspects. So you do a legal due diligence, and also for technology companies, it's the IT due diligence, which is important. And of late, there have been ESG due diligence that's also happening, especially with the larger companies. Next slide, please. This I'll not go into deep because Shivan's already talked about the regulatory framework in more detail, and this is just a small listing of the different legislations or the statutes which come into play when it comes to acquisitions. Next slide. Now, post M&A integration, this is very significant. I mean, you've done a new due diligence, you've shaken hands, you've come together, right? You start working together, and now you see what is coming your way, right? And when there is a change management strategies have to be employed very, very smoothly, because I mean, uh, the success mantra is, how do you uh, function after the integration takes place, right? Because they have a particular way of uh, functioning, and now you come and implement new processes. There will be some resistance, there will be some conflicts, and that is where the change management strategies have to be adopted to make sure that those things are smooth. So uh, then there could be different financial recording methodologies. You can follow US GAAP, you can follow IFRS. The Indian company may be following IGAP. So you have to integrate the accounting policies. You have to make sure that the consolidation happens in the right manner. Uh, then there are legal compliance aspects. Culture, I talked about it. That's the most significant part in a post integration aspect, and this has to be taken care of, really. uh, and then we'll have to see how the operational synergies can add value to the joint venture or to the integrated entity that you've taken over. uh, Next slide, please. These are some of the common pitfalls that one looks at when you're talking about an acquisition or a merger, and also how do you work around them or how you get around them. So the common pitfalls would be that you have done a valuation and have you acquired, and suddenly you realize that the valuation is an overvaluation, right? The company is not worth that. So then there was a lacuna in the valuation process. Probably uh, one was more optimistic than what it was. So that's something one has to be very careful of. Suddenly you come up with unexpected tax liabilities. That creates a huge pressure on the new entity. There could be cultural clashes leading to workforce resistance. There could also be delays in obtaining approvals. That could pause the operations and hurt the business. So, what are the mitigation strategies? You conduct enhanced due diligence exercise. You structure earnouts to take care of the valuation aspects. So, you can ask, you can, to the potential seller, you can tell that, okay, we value this at X price, but of this X price, we'll pay you so much only after a year, only after 2 years, after we've seen that the business actually is working. Uh, Establishing strong post-merger governance, engaging with employees, doing town halls, that's very significant, because they need to understand your vision, your mission, what is the way you want to take that company forward. And obviously, I mean, once you appoint the right advisors, right accountants who will help you navigate all this, I mean, that's something which is a given that you'll have to do, you'll have to engage with that, with those people, those experts. Next slide, please. Some case studies of Indo-Japanese M&A, SoftBank investments, I've already talked about it. Suzuki's partnership with Maruti, Daikin's acquisition in the HVAC industry. What are the lessons learned? Yes, importance of cultural alignment, role of structured integration planning, and continuous regulatory engagement. And we've seen, we all know about the Daiichi Sankyo Ranbaxy transaction, which didn't go well, right? And I think one of the primary reasons was the failure of the due diligence to identify that there are issues in the US FDA and there are liabilities sitting on it, which were never identified, and there were non-compliances, right? So that's a very good case study for people to take as a lesson going forward when they do a partnership in India. And having said that, there have been numerous successful partnerships because they have done that. I mean, those aspects were taken care of. I mean, one of the examples is the Walmart acquisition of Flipkart in India, right? That happened very successfully. I mean, they took care of all regulatory aspects, made sure that all those regulatory aspects were addressed and all that. Next slide, please. So that's so as I come to the conclusion, just key takeaways. India offers strong M&A opportunities, but it requires very careful navigation. That's a rider that I would want to say here. Due diligence is critical across financial, legal, operational, and cultural dimensions. Post-M&A integration must be planned for smooth transitions, and regulatory compliance is crucial for seamless transactions. So this is what I have to offer in this 20-25 minute short period, but I'm happy to take questions if anyone has anything to ask. I can take it offline also. Thank you very much. Thank you.
Thank you, sir, for your presentation. Next, I would like to request Mr. Subodh Prasad Deo, partner Kundra and Bansal Associate, to make a presentation on competition law and M&A before and after. 続きまして、クンドラ&バンサルアソシエイトパートナー、スブト・プラサドデオ様より競争法と M&A その前後についてのご講演をいただきます。
Minasan konnichiwa. Good afternoon, everyone. I'm going to speak about competition law and how it interacts with mergers and acquisitions, primarily. So, just as we have the Japanese Fair Trade Commission in India, in Japan, we have the Competition Commission of India in India. It's a government-nominated body whose job is primarily to ensure that there is competition amongst the businesses, and competition should be such, or the businesses must conduct themselves in a manner that it does not cause any appreciable adverse effect on competition in India. So that is the mandate of the Competition Commission of India primarily. And how does it do this? So the Competition Commission of India, so there are two parts to it. One part is the enforcement part that takes care of anti-competitive agreements, abuse of dominant position. And the third part is it screens potentially those mergers and acquisitions which can or which have the potential to cause anti-competitive effects in the Indian market, right? So this is primarily the work of the Competition Commission of India. And since the topic for the day is mergers and acquisition, let me first deal with the mergers and acquisitions part as to how does the Competition Commission of India review the mergers and acquisitions. So first of all, the important point to know is there are prescribed statutory assets and turnover thresholds, which means the acquiring entity and the target entity which the acquirer is acquiring, or in case of amalgamations and mergers, the assets and turnover of both. So there are financial thresholds which are defined under the Act, and those, if you breach those, then you cannot go ahead with the mergers and acquisition till such time the Competition Commission of India has looked at it and has cleared it. May I request to straight away come to slide 8, please. Next, please. Yes, thank you very much. So these are the assets and turnover thresholds that I was talking about. So India has a suspensory regime. What does that mean? That primarily means that if you breach any of these thresholds, there are 8 thresholds primarily. So these thresholds are at the enterprise level, which means that if the acquirer and the target entity whose shares, voting rights, or control you are seeking to acquire, if the assets are more than 2,500 crores, which basically translates into, I'll just tell you the number, approximately 287 million USD, roughly about 287 million USD. If you breach that, that means the combined assets of the acquirer entity and the target entity breaches 287 million USD, then it becomes a fileable transaction, which means you cannot go ahead with the transaction till such time the Competition Commission of India has reviewed it and has approved it. And they have a timeline of 150 calendar days, but more than 95% of such transactions get approved within a period of 30 calendar days, excluding the time taken by the CCI to ask for information and the parties to furnish the relevant information to the Commission. So similarly, we have eight such, and if you meet any of those, then it becomes a notifiable transaction. Now, of late, since 2019, the Competition Commission of India has come up with a green channel route. And the green channel route means on the day you do the filing, it is deemed to be approved. And how does it work? So if the acquiring party and the target do not have any horizontal, which means they are not competitors, they are not into competing business, or they do not have any vertical relationship, which means they are the target and the acquiring party are not placed at different levels of the market. So if you don't have either a horizontal or a vertical or a complementary relationship with the target entity, then you simply have to file if you breach any of these, and on the day of the filing itself, it will be deemed to be approved by the CCI. So this is a very innovative thing that the Competition Commission of India has come up with. And as I explained, horizontal relationship basically means a relationship of competition. A vertical relationship will mean basically a relationship where you are placed at different levels of the supply chain. That means somebody is a manufacturer and the other party is a distributor. So that is a vertical relationship. And complementary typically means that if the price of one product increases, the price of the other the demand for the other product also goes down, basically. So like ink and pen, they are in a complementary relationship. So if you don't have any horizontal, vertical, or complementary relationship, then on the day of the filing itself, it will be deemed to be approved. Otherwise, you have to make a filing. Filings are done in two manners. One is called a Form 1 filing, and the second one is called a Form 2 filing. Form 1 filing and Form 2 filing, the distinction between the two are primarily that if the target and the acquirer, if both of them have more than 15% of the market share, then it is advisable for the parties to make a Form 2 filing, which is a more detailed filing. Similarly, if the parties have more than 25% of the market share in vertical markets, then it is advisable to file in Form 2. Of course, it is the discretion of the parties, but the CCI might come back to you and it might tell you that, look, since there is huge overlap, you might as well file Form 2. And the filing fees also differ accordingly. Now, since October 2024, the Competition Commission of India has come up with something known as the deal value threshold. And the deal value threshold basically means that irrespective of these assets and turnover thresholds, if the deal value, that means the transaction value, crosses 2,000 crores INR, which means roughly about 240 million USD. If the deal value is 240 million USD, then you have to necessarily make a filing. And this has been done primarily because it was realized that several startups, maybe technology startups, maybe startups in biotechnology and other areas, they don't have huge assets and turnover, but they have huge potential and their valuations are very high. So for instance, just to give an example, the acquisition of WhatsApp by Facebook, it escaped the attention of the Indian competition authorities because at that point of time, WhatsApp did not meet the de minimis threshold, and I've just explained this de minimis threshold, and therefore, it was not fileable. So, in order to ensure that acquirers do not gobble up potential competitors, the Indian competition regulator has come up with what is known as the deal value threshold, which primarily means that if you cross the deal value is more than 2,000 crores INR, Indian rupee, or which is equivalent to roughly about 240 million USD, then irrespective of everything, that transaction will become a fileable transaction, right? In addition to this, these threshold, what is important to note is that there are certain de minimis exemptions given under the law, which means so next slide, please. Yeah. So this is the de minimis exemption that I was talking about. So even if you breach the asset and the turnover threshold, which was there on the previous slide, but if the target's asset is less than INR 450 crores, which is USD 56 million, or the target's turnover is less than INR 1250 crores, USD 156 million, and both must be satisfied, then you don't require to file even if you breach the asset and turnover threshold. So this is called small target exemption. So for instance, if a Japanese company is acquiring a target in India and the assets and turnover of that target is less than this amount, then it will not be a fileable transaction, even if the combined assets of the acquirer and the target breach the assets and turnover threshold. I hope I'm clear. In addition to this, there are certain other exemptions which are available to the parties, like which is known as solely as an investment. Solely as an investment would primarily mean where the acquisition is where you acquire up to 25% of the voting or the shares of a company, but you don't take any control rights. And the control right means the right to appoint to the board of directors or access to competitively sensitive information by way of an observer right. If you don't take any of these rights, then that might qualify as solely as an investment, and that would be exempt. Similarly, investments made in the ordinary course of business. What does that mean? That primarily means this is now limited to investments by the underwriters, the stockbrokers, and the mutual funds. So there is a limit defined to them. Similarly, in case of demergers, when the new company is opened and issuance of shares are there, those are also exempt. creeping acquisitions, which means you already own 0 to 25% of the shareholding, or 25% to 50% of the shareholding, or 50 to 75% of the shareholding, and you increase that shareholding, then those would also be exempt, provided there is no change in control. And control, ladies and gentlemen, is very, very widely defined under the Indian statute. So control would basically mean any right that you have beyond what an ordinary shareholder of that company has would mean that you have a control right over that company, even if it is an observer right. That is also construed as a control right. So this is all that I want to say about the mergers and acquisitions. Once you have merged and acquired an Indian company, either you have acquired shares or voting rights or anything of that sort, the second part comes into play, and which is your conduct. And by conduct, I mean, whether you are behaving in a competitive manner or in an anti-competitive manner in the Indian market. And so primarily we have two kinds of anti-competitive agreements. One is known as a horizontal agreement, and the other is known as a vertical agreement. Now, horizontal agreements are agreements which are amongst or in between the competitors. So one competitor agreeing with another competitor to fix prices or to allocate market or to, indulge in bid rigging, things of that sort. A cartel conduct, primarily a cartel conduct. Those are presumed to be anti-competitive, and the onus is shifted onto the charged parties to rebut that presumption. Right? It's a rebuttable presumption, but if there is any evidence of anti-competitive agreement between competitors, then the onus is on the charged party. Similarly, in case of vertical agreements, if you are operating at different levels of the marketplace and you enter into some kind of an anti-competitive agreement, it is not prohibited per se, because businesses are all about vertical agreements. What is prohibited is if that agreement causes or is likely to cause an appreciable adverse effect on competition. And the onus is on the Director General of the Competition Commission of India to establish that said agreement has caused an appreciable adverse effect on competition. And the third is, of course, abuse of dominant position. Dominance primarily means the ability to exercise, your market behavior independent of your competitors. So this is in sum and substance the regulatory model of the Competition Commission of India under which we operate. And I think the Competition Commission of India is a pretty fair body, and it passes very detailed orders, and so most of the orders are quite convincing in their nature. With this, I will end my presentation, and if you have any questions to ask, I will be happy to answer them. Thank you very much. Thank you.
Thank you, sir, for your presentation. If there's any question, please ask. Okay. If there's no question, then we will go ahead to the next program. So next, I would like to request Mr. Masanori Uzawa, General Manager, Business Planning and Administration Department, Sumitomo Chemical Corporate Limited, to make a presentation on Japanese business success stories in India. 続きまして、住友化学株式会社事業企画総務部ゼネラルマネージャー宇沢正則様よりインドにおける日本ビジネスの成功事例としてご講演をいただきたいと思います。よろしくお願いします。
はい、ご紹介いただきありがとうございます。皆さんこんにちは。Thank you everyone. And then it's a very great honor to be here. And then again, thank you very much for having me. And then I just want to say thank you to the presenters, Shibang and Alok. It was a great presentation. And then I'm still wondering if I should keep going on in English or I should switch to Japanese? Looks like kind of half and half Japanese speakers and then, non-Japanese. Okay. So I'm going to switch to the Japanese. じゃあすいません。次のスライドお願いします。
So founded in 1913 and 72 and also we have the 184 subsidiaries across the world, and the consolidated revenue is 2.4 trillion, and also this is the breakdown of the category, as you can see. So it's quite wide range of the chemicals or chemistry related. So the basic chemicals, bulk chemicals, which is the oil chemicals, from the plastic to the medical related, healthcare related, and also R&D driven chemicals that we are doing the production and the sales. And also, and what we want to introduce in the pie chart left side, this light green, 22% health and crop science that we would like to introduce. So we want to talk about this sector. So we are the subsidiaries of this health and crop science. Next slide. And the health and crop sector. So from last October, we changed the name. So it's Agro and Life Solutions business. The Agro and Life Solution, what kind of production products that we are deploying? So especially with the agro solutions like crop protection products such as insecticides or the other ones, cockroach or the mosquitoes to kill them, and also for the animal nutrition. So we are working on these three sectors. So this Sumitomo Chemical India is a agro solution is what we are working on. And in the chemical industry, maybe you would not be common. So this is the brief overview. So this is a global business expansion in agro solutions. So 5 billion US dollars, which is that big of the market, and top 12 countries that you can select, and also this is the bar chart scale. So the biggest one is the Brazil, United States, China, and also India is also significant market, and the size is actually in the fifth place, and the fifth rank, but using Sumitomo Chemical in this agro solution, India is quite important, which is it's more than ranked as a number 5. So because of the growth of the market potential, 12 country, India is the most have the significant growth. And our Sumitomo Chemical from the top 20 countries, so nine nations that we are deploying, and by doing so, the M&A is something that is placing a very important role. And also in India in 2016, so the Excel Crop Care, which is the excellent company, we engaged this business, and also we merged, and also 100 we did the merger with the 100% the subsidiaries of them. So this was a great leap in India. Next page. So as you can see, the simple structure here, the pre-merger on the left and also the right is the post-merger. So originally our company, so from we run the subsidiaries from 2000, and also we had the organic growth, and also on the Sumitomo Chemical, which is a parent company, and Sumitomo Chemical India Limited. So we acquire 65% of the Excel Crops Care to engage in this initiative. And also Excel Crop Care is the listed company. So the list, we merge 100% of the subsidiaries is something that we did in 2018. As a result, as you can see on the right-hand side, so the Excel Crop Care and the Mars, this is a new Sumitomo Chemical India, is as you can see with the ratio, 80% of Sumitomo Chemical public and listed company. So the general stakeholders, 19.7%, which is a new company. Next page. So what great about this merger? It was quite complementary. So that means, so in the running of the business, there are a lot of synergies across the segments. So in the manufacturing, both had the plant of the manufacturing, and originally Sumitomo Chemical had 100%, which is all Sumitomo Chemical India. The formula is actually the downstream function, but Excel Crop Care had the upstream was the it's more the technical braid that they actually had as a capability, which was quite complementary, and also the distribution function, adding both then more than 13,000 distributors that they can cover. So with the pan India, so we could actually cover those. So which was quite a big synergy. And also with the products portfolio, as you can see, it's quite wide range. Pre-merger Sumitomo Chemical India, and also the insecticide, which and also the other ones, fungicides, that we could enhance the portfolio, and it was a great balance of the product. And the next is from the risk perspective. So in this business, the health and also the seasonal sensitivity is there. So the crops of the what kind of the chemical used to the crop is quite important. And pre-merger Sumitomo, so or the after Excel Crop Care, which we bought. So in the season of the summer season, there they had a lot of products, which is the scope of the summer crop. So this is by merging with them, we could actually apply to outside the summer season as well. So we could actually have the great synergy there as well. And since we're running out of time, we move on. So this is a successful merger in 2010 and 2018 revenue comparison. It's more than 10 times, and it's a billion Indian rupee is the unit. So as of 18, so it was 260. And also in the year of 28, so 28 billion rupee, so which is a great significant momentum. And the next slide. So this is the listed company. So the stock exchange was also paying attention, as you can see. After the merger, relisted, but the stock price was doubled, and the market cap is 227 230 billion Indian rupee, which is in JPY probably 40 million yen. So for Sumitomo Chemicals, it's quite important asset. And the next slide. So this is the key takeaways. Margin acquisition through we learned some of the aspects. So the important point is the trustable or reliable partner is important. This meaning many things, but so the talents we can rely on the business operations, and also finding them in early stages is important, and also in the course of their growth. As we said, there's a M&A activity, so to consult the advisor like a law firm or any accountant that we would need to have as a business partner, and we could find in early stage, and we have the long-term trustable partner, then this can be the great power to be success. And the second one is the long-term commitment, which I wrote down. So Sumitomo Chemical, we started the agro solutions from 2002. For the first 10 years, it was not really a great growth. So it was a try and error period. And also for the Indian business, it was actually a important period to get to know the Indian culture or the business. That was a great important moment. And we didn't give up those days. And at the great timing of the M&A, then we could actually have a great jump. And lastly, it relates to the above two, but so the market business opportunity, it's if we move after we get the opportunity, it's actually too late sometimes. So if we can move a little bit earlier, then it's best, but it's very difficult to find the timing. But we are very fortunate. So right before the growth of the agro solution in India, we could actually get to this opportunity. So which was quite lucky. We were lucky enough, and also as I said, we could find a partner, a trustable partner, and also we could our management, top management, actually committed to the long-term perspective. So that was actually the tailwind to this commitment. So that was one step ahead of the time. Was great opportunity. Thank you very much. That's all.
インド企業と日本企業の M&A とジョイントベンチャー法的視点からを終了とさせていただきます。We will have a networking session with light refreshment at the foyer outside of this venue from now on. We hope you all will join us. この後ネットワーキングセッションをこの会場でですぐのフォアイエで開催いたします。軽食もございますので皆様ぜひご参加くださいませ。Thank you very much for your participation today. 同時通訳レシーバーをご利用になりました方は、受付までご返却お願いいたします。If you have used simultaneous interpretation receiver, please return to the reception desk. Thank you very much.